car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Welcome to the attorneys. I'm Art Franklin. So glad to have you with us. So on this show, we're going to be talking about medical negligence and also medical malpractice. You know, when there are mistakes in the medical world, it can really be life-altering for that patient. But we're not only talking about for patients, also for practitioners as well. As we get over to Hollis Wright team here, Carter Clay and also Michael Eldridge, talking about medical malpractice.
Yeah, absolutely. And I always like to start these types of shows out by saying that we have an incredible medical community here throughout the state of Alabama. Some of the finest doctors and healthcare professionals you'll find anywhere. But like anybody, they're not infallible. They are susceptible to making mistakes. And when they make mistakes or they commit malpractice or negligence, as we refer to it from time to time, it can have life-altering consequences to the patients, and it can have professional consequences to the practitioner. And that's sort of where Hollis Wright and other law firms that handle these types of cases come into the picture to represent patients and or families of patients who have been victimized by malpractice or mistakes in the medical field. And we can represent them and try and achieve compensation for them for those injuries. And Michael Eldridge, my partner, is here with us here this evening. He's handled medical malpractice cases in the past, done a great job handling those types of cases. So we've got a lot to cover tonight.
We do, and honestly, Carter, I don't know what your experience is, but I would say just in terms of the calls that we get and people reaching out to Hollis Wright, and by the way, the circumstances and the types of claims that we get and the questions that we get vary many subjects. I would say this is probably the most common call, and I think there's a couple of reasons for that that we can touch on. But when we're talking about medical malpractices, or as you said, or medical negligence as some call it, what we're talking about is a professional negligence. And specifically what we mean is in the healthcare profession, where that's doctors, nurses, it spans a lot of different professions. A situation where there was conduct or either the lack of conduct, they failed to do something that fell below the standard of care. And as a result, and that's a very important part of it, those are not just words, as a result, and we'll get to that, someone was injured or they were caused death. And all of those words, it's much different than what we call a general negligence case or a general personal injuries case. All of those words matter so much in medical malpractice. What it means to be the standard of care, what it means in terms of medical causation, and tying all of those things together within the framework, at least in Alabama, of the Medical Malpractice Act, is a very complicated thing.
Yeah, and you touched upon this a minute ago, so let's go ahead and dive into it. We do get a lot of these calls, and the reality of it is that I believe the reason we get a lot of calls about this, it's not a negative reflection on the medical community, because the overwhelming majority of the calls that we get, they're not victimized by malpractice, but in my opinion, it has to do with the patient having, I don't want to say false expectations, but expectations that every time they get treatment or a surgery from a doctor, their expectation is they're going to have a positive result.
That's right. And I think the point is that just because in medicine, and this it goes without saying, there are going to be negative results that do not amount to a breach of the standard of care. Or negligence. Bad things are going to happen in medicine, and the doctor did nothing wrong, or maybe the doctor didn't do exactly what they were supposed to, but that was not what caused it. And so that's why we end up getting these calls, because a lot of people, when they go into hospitals, are already prone for something bad to happen, and when something bad does happen, they call an attorney, which I encourage them to do, but most of those cases are turned down.
Can I talk about this if I can? So say there's been a mistake. There's some form of negligence or malpractice that has taken place, and they need to talk to someone from Hollis Wright. Walk us through the process of actually filing that lawsuit.
Yeah, so I'll take that. So a lot of times people will get frustrated when they're talking to a lawyer about medical malpractice, and the reason is because the lawyer wants to talk about something different than what the caller or the patient wants to talk about. And what I mean by that is, from a legal standpoint, the lawyer typically is going to start with the injury. Okay, the reason is because these cases are very expensive to pursue. They're very challenging. They're some of the most difficult cases to win. Oftentimes they involve complex areas of medicine. And because of that, you really got to have a catastrophic injury, a permanent injury, a death, to even really warrant looking into it. Okay, so that's sort of always the starting point. But typically people want to call in and they want to spend a lot of time talking about what happened to them, how the doctor or the physical therapist or the nurse messed up, and the lawyer's constantly trying to get to the end point, which is okay, how badly were you hurt? Because if you weren't hurt that badly, unfortunately, it's probably not going to be a case that can be pursued, because we handle all of these cases on a contingency fee basis, which means we don't get paid unless we successfully recover for our client, and we advance all those expenses. These cases can be $50,000, $100,000 plus just in expenses alone, so the injury has to be there to justify that type of investment. So I want Michael to talk about then, if we actually take the case, what they can expect.
Well, if you do accept a medical malpractice case, it's very different than, let's just say, even a trucking accident, which is not simple. Because in terms of proving a medical malpractice case, as opposed to a trucking or a car accident case, which is very factually driven, right? What happened? What was the rules of the road? Who did what? To prove a medical malpractice case, it's all proved through experts. And so that's where it gets very expensive, right? What Carter was talking about, it could be 50, 100, sometimes more than $100,000 but if you need multiple experts in order to prove your case. And so we have to spend a lot of time, and especially when we get these cases 6 months before the statute, which you only have 2 years generally to file these cases from the date of the malpractice. We don't have time, because in order to get to a position to file a lawsuit, we've got to meet with experts. We've got to determine whether or not you breached the standard of care. We've got to determine what the standard of care was. And I think it's important to explain what I mean by that. In Alabama, every situation, and it depends on what kind of doctor it is, what the type of surgery, what type of treatment it is, there's going to be a nationally recognized standard of care, which, by the way, the experts are going to have differing opinions on in terms of the circumstances in any given cases. The defense experts are going to say one thing, the plaintiff's experts are going to say the other, but all of it has to be proven through experts. And that takes time, and it takes the attorneys sitting down, number one, finding the right expert, an expert that's going to be able to pass the muster in Alabama. And so it's not a situation where it comes in and Carter and I look at it and we go, let's type up a lawsuit and file it. Right. There's a lot of energy that has to go into it in terms of evaluating it, even if you know that you've got a viable claim.
Yeah, so that's really a big part. If we take the case, it's a very expert-intensive case. These experts have to be similarly situated experts, and we're going to talk more about that on the back end of the break, that identifies who these experts are, what types of qualifications they have to have in order to even be able to testify in court.
So that's the comprehensive answer to that question. So if you're at home and you're thinking about that and you think you may have a medical malpractice or a negligence case, get in contact with someone at Hollis Wright. That's why we have this team. I said the team from Hollis Wright with Michael Eldridge and also Carter Clay. Also listening to you. All you have to do is call 1-844-LAW-TALK, and you can reach someone from Hollis Wright right now. Lawyers are standing by. They're taking your calls live right now, and we'll do it throughout the show. It's a free call. It's confidential. As we continue with the show on medical malpractice and negligence, right here on The Attorneys. We'll take a break, but we'll be back in a few.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Hollis Wright has been handling workplace injury cases for years. If you've been injured on the job, give us a call. Our attorneys are standing by right now to give you a free consultation. And remember, at Hollis Wright, your result matters.
As we welcome you back to The Attorneys, I want to remind you that you can follow Hollis Wright on all the social media channels, on X, on Facebook, on Instagram. Also, there are a couple of numbers on the bottom of your screen that you may see scrolling there on the bottom of your screen. You can use those numbers to text your question to Hollis Wright, and they'll get that back to you. Also, 1-844-LAW-TALK. That's an attorney from Hollis Wright standing by live right now to take your call. And we are talking about medical malpractice and negligence. It sounds very complicated, but you guys make it seem understandable.
Well, I appreciate that, but yeah, it is complicated and it's also expensive. We were talking about experts before we went to the break. So if we take a medical malpractice case, typically, you're not required under the law in Alabama to have an expert before you file a lawsuit. Sometimes states out there require you to have an expert, and you actually have to file something with the court, or you have to have a statement from that expert explaining why the defendant that you're suing actually did something wrong, the circumstances behind it, et cetera. We don't have that requirement in Alabama. However, that does not mean that you should file a lawsuit without talking to an expert before you file the lawsuit. That can get you in a lot of trouble. So as a matter of course, we're going to talk with experts before we actually file the lawsuit. But once the lawsuit is filed, as I mentioned before we went to the break, you have to have what's called a similarly situated expert. Okay, what that means is that if you're suing an orthopedic surgeon or a neurosurgeon or a cardiologist, your expert's got to be a neurosurgeon, an orthopedic surgeon, or a cardiologist, depending upon what discipline you're dealing with. We get all kinds of calls, Art, all the time where somebody's complaining about something that, let's say, a surgeon did, where they say, well, my uncle is an internal medicine doctor, and my uncle says that the surgeon should have done it this way and that way. Well, that's fine that your uncle has that opinion, but your uncle, as an internal medicine doctor, would never be able to testify about what a surgeon should be doing in this type of procedure. So that's just one of many nuanced examples of challenges that we oftentimes face in the medical malpractice arena, and I think Michael would concur with that.
Yeah, I would go further in terms of the experts, and we get this question all the time from clients, we get it from jurors, and people wanting to know, why were your experts from Florida? Why were they from California? Why were they from Texas? Why weren't they from Alabama? Why didn't you get experts from Alabama? And that's because in almost every circumstance where we file a case and we're having to bring an expert in, we're required to bring a similarly situated expert in, it's going to be an out-of-state expert. There's some very obvious reasons for that. If you got to get a similarly situated doctor, and let's say it's an orthopedic surgeon, like you said, finding another orthopedic surgeon that does exactly what this other Alabama orthopedic surgeon does, they're a part of all of the same organization. They probably refer each other cases. They might have, have privileges at the same hospitals. They're going to be hesitant to testify about how this doctor breached the standard of care. But then there's other issues in terms of You got these medical staffing companies that are paying a lot of these doctors that have contracts that say, if you testify against one of our doctors, then we're not going to, that's a breach of our contract. And I think the most important one, at least in the state of Alabama, most of these doctors and these hospitals and these nursing staffs, there's only a handful of insurers, and they're all insured by the same people basically, and they have rules within their insuring agreements about not testifying against their own insureds, and that's for obvious reasons, right? Those insurance companies don't want to lose money and have doctors, and so it makes it even more difficult, even when we have very viable and very valid medical malpractice claims, that we're going to have to go and hopefully find the best of the best experts, but sometimes they're all the way out in California.
Yeah, and this is probably a good time to point out we're not picking on doctors, sort of a good old boy network sticking up for each other. The reality of it is if it's a legal malpractice claim, it's probably going to be difficult for us or anybody to find another lawyer to testify against another lawyer in terms of something they did. If it's engineering or accounting, that issue you're going to confront in any type of professional malpractice claim that you're bringing.
This question from David here, I want to go ahead and take, if you guys can take that for me. Say, what do you say to those people who believe that there are too many medical malpractice lawsuits, or that verdicts in medical malpractice lawsuits are just too big or they're out of control?
Well, what I can tell you is that I disagree with the premise of the question.
Okay.
Because I don't think that the statistics even come close to bearing that out. People are shocked when we tell them how many calls that we get in terms of somebody interested in pursuing a medical malpractice claim that we turn down, and that we only take a handful. I would say we probably turn down 95 out of 100. Of every 100 that we look at, and then out of those 5, ultimately we may investigate and turn down 2 or 3 more, and we may only pursue or file 1 or 2 of the 100 that we look at. So there are a lot that don't ever get filed. Now, with respect to the 1 or 2 that we file and that other medical malpractice attorneys file, is when those cases get filed, you're oftentimes, and really always, dealing with a catastrophic permanent injury or a death. So remember, I talked to you at the beginning of the show about how you really want to focus on the injuries first. So it stands to reason that of all the medical malpractice cases that actually are filed, if they all involve a catastrophic injury or death, you are going to have verdicts from time to time that are several $1 million. But if you look at statistically at those verdicts, you're going to look at those and be like, they were justified. This person's in a wheelchair, or this person was 40 years old and they lost their life as a result of this malpractice. So I would disagree with the premise of the question. I understand why people would ask that question, but I just don't think that's the reality.
Yeah, and I think the empirical data is going to show you that that's not the reality. And obviously, these are not doctors out here saying that, in my experience, right? These are talking points from a political standpoint that we hear all the time about that litigious towards doctors, and most people understand why. But the fact is, if you look at the data in Alabama, it's one of, as a statute, it protects doctors and healthcare facilities as much as any medical malpractice statute in the country.
Yeah. All right.
After the break, I want to talk about statute of limitations. This is always a big topic that we have with the callers that call into our office, and I think the viewers will be interested to hear it.
All right, as we go to break, I want to remind you you have just a little bit more time to reach an attorney live right now at Hollis Wright to get your question answered or comments you want to make to that attorney. That question is confidential, and it is also free. All you have to do is call 1-844-LAW-TALK. Go ahead and do that. We'll be right back after this short break.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon. The firm's motto is "Your result matters," and we mean that sincerely. Hollis Wright handles cases every day for those at their lowest point, and will do whatever it takes to get the result you deserve. At Hollis Wright, your result matters.
Welcome back to The Attorneys. We're rolling towards the end of the show. I want to remind you, though, that you can still reach someone right now. If you have a question, you can contact someone at Hollis Wright by calling 1-844-LAW-TALK for a free confidential call with them. And this is a very important and complicated topic that we're discussing: medical malpractice and negligence.
Yeah, going back to the question you asked early on in the show, what can
From
somebody...
David?
Well, no, from your question
Okay.
about what can they expect early on if you file a lawsuit. I think that's a great starting point for all of this. We talked a lot about the experts, but I think if we file a lawsuit, what the viewer can expect or our client can expect is it's typically going to be a couple-year process in order to either get the case resolved or get it to trial. Initially, after we file the lawsuit, there will be what we call a paper discovery phase that involves interrogatories and requests for production, which are like written requests. There's going to be a lot of gathering of documentation. And then we transition into the deposition phase, where our client will have to give deposition testimony. We will take the depositions of the healthcare providers, the nurses, whatever the case may be. Then we transition into that expert phase, where we actually disclose the experts that we have in a case. The experts we talked about can be standard of care experts. We hire an expert to say that the doctor did something wrong. One thing that we haven't mentioned, though, that is critically important in these cases is oftentimes we have to hire another expert, and that expert has to address what we call causation. Did the misconduct, the wrongdoing, did it cause the injury that we're complaining about? And that's oftentimes a complicated question, but sometimes we have to hire a separate expert, medical doctor, to come in and explain how the mistake or the wrongdoing actually caused the end result or the injury that we're complaining about. And that can be a big part of the case as well. But then once we get through the expert phase, we're pretty much at that point getting to a point to where we could actually try the case if it goes unresolved. But I want Michael to jump in here and talk a little bit about the damages that if we go to trial or if we're getting ready to resolve the claim, what are the types of damages that we can get? And you can talk about wrongful death, I guess, and also personal injury.
Well, I was going to start there with the wrongful death, and I want to kind of piggyback a little bit on your causation, because at the beginning of the show you may have heard me say that as a result, and I stopped and I said focus on that as a result, because that's very, very important. When we evaluate these cases on the front end, that is such a big factor, because a lot of these people have what the medical community is going to call comorbids, right? Things that they already had that were wrong with them that could contribute. And when you have a bunch of those and then something goes wrong in a hospital, determining what the actual cause was, especially when someone dies, if there's not an autopsy, becomes very, very difficult. And that's where it goes in terms of what Carter was saying about having a separate expert. But let's start with wrongful death, because it's totally different than a case where the plaintiff is still alive, because we have the medical mal statute, the med mal statute, but we've also got the Alabama wrongful death statute, which is in essence a punitive only type damages, meaning damages to deter that type of behavior in the future. Whereas if the person is still alive, the damages are not much different than a personal injury case, right? It's going to be the same thing as if you had to incur more medical bills, out-of-pocket expenses that are associated with whatever the injury was that you were able to tie to the breach of the standard of care. It's going to be the pain and suffering. It's going to be any mental anguish that's associated with it, loss of income. If you've got a permanent injury, that obviously matters, and especially depending on your age, how long you're going to have to deal with that permanent injury. And so all of those are factors in determining what your damages are in a medical malpractice.
Yeah, and I think one thing I want to mention, we talked about injuries needing to be catastrophic or permanent. There is one exception to that. The exception to that is if the breach or the wrongdoing is so obvious that perhaps that's a situation where the injuries don't have to be catastrophic or debilitating. I'll give you an extreme example. Let's say that somebody's got bad circulation in their toes, and they've got to get their pinky toe amputated. And the doctor is supposed to be amputating the right pinky toe, but he makes a mistake and amputates the left pinky toe. Now, that's not a catastrophic injury that somebody has sustained that's going to involve a lifelong disability, but it's still an injury, right? And it's still meaningful to them. But the breach, the wrongdoing is so obvious in that situation, no doctor could credibly argue, I don't think, that, that was justified. So that would be an exception to that situation in terms of the injuries having to be so severe. But I want to jump into statute of limitations.
Okay.
That's always important in these particular cases. Mike, you start us off with sort of what the boilerplate statute of limitations is, and then I'll sort of piggyback on what your comments.
Yeah, so generally the statute of limitations, and what we mean when we say statute of limitations, if you don't know, is that is the deadline for you to file a lawsuit. And whatever your applicable statute of limitations are, if you go one day past it, they don't give you any relief. It is a hard line in the sand. And so the general statute of limitations for a claim for medical malpractice is going to be 2 years. However, there are some narrow exceptions to that, and those are going to be centered around mainly children, but also there is this idea, Carter, and you can explain to us about when you discover that the malpractice occurred, because there are certain circumstances that you would not know the day of.
Yeah, so with children, it's a little bit different. We don't have time today to get into all of that right now, but children have more time to bring a medical malpractice claim. With adults, however, it's 2 years with some exceptions. And the reason why this is so important is oftentimes we get a call of somebody that says, I have cancer, and I went to a doctor visit a year ago and they examined me. I think I had cancer then. They missed it or they didn't diagnose me, and I want to file a lawsuit. Well, you're still within that 2-year window, so you're still good at that point. But if you're after the 2 years, right, you find out that whatever happened to you, the malpractice was more than 2 years ago, you may have an additional 6 months to pursue that claim, okay? However, here's the ultimate key is under no circumstances can you bring a claim against a doctor or a healthcare professional for malpractice that occurred 4 or more years ago. So if the malpractice you're complaining of was 5 years ago or 6 years ago or 7 years ago, it does not matter that you just found out about it. You are simply out of luck. And that's to some extent a harsh result, but philosophy is you've got to cut these things off at some point. You can't allow these situations to go off into perpetuity and allow the exposure of the healthcare professional to last forever. So that's really the foundation behind having the statute of limitations or the statutes of repose, which are the 4-year outer limits.
And it's another reason, Art, why it's important to get to an attorney very quickly. Because it takes time to evaluate these things, and these are hard deadlines.
Complicated case, complicated issue, but made a little bit more simple because you heard it right here on Hollis Wright Show. So this is the attorneys. This is where you get the information. Always listening to you. We want you to also follow Hollis Wright on all social media platforms so you can continue to get information throughout the week, and then make an appointment to join us again next Sunday, same place, same time. We'll see you back there then.
Thanks for watching The Attorneys, sponsored by Hollis Wright.